Welcome to the Settle Law Clinic's podcast.
So there are instances where parents disinherit their children because they might feel, well, this particular child feels entitled and I've done all I can for this child or all I should for this child in my lifetime. People get this misconception that you only put your house in order when something is about to happen. No. Think of estate planning as organizing your life for time. It's more like taking pots to ensure that the things you have acquired in your lifetime is well catered for. People think is when you actually do the will. That is when you have started estate planning. No. It starts from how well you safeguard your assets. It's not for the old alone. It's not about the age. It's not how long, but how well. Success is not measured in a lifetime. Success is measured in phases. A will is a legal instrument that contains the desires, the instructions and the directives of a person in his lifetime. The people witnessing your will cannot be beneficiaries to your will because your will is supposed to be a secret. If the witness to your will is a beneficiary to your will, then that's a ground for invalidity. In real life, wills are not read in your lawyer's office. The person dies, your will is not read in your living room. Your wills will be read at the probate registry.
Hello and welcome. My name is Adini Kyoyarikwa and I'm your host. This episode is a continuation of our conversation on estate planning. Before we start, can you do me a favor? Click the subscribe button and turn on your notification. That way you'll be the first to know when we drop the next episode, and at the same time you'll be helping us grow this podcast channel to be able to reach more people who can also benefit from the information shared. Also, don't forget to like, share and comment on this content. It helps us know which topics are beneficial to you, and we can continue to create more content like this. Thank you so much. So let's get into today's conversation.
So you've prepared the will, you've been updating it by doing your codicil to it and things are happening. Now, where do you store these wills and codicil? Do you store it in your house? I ask this question because I know you know where I'm going with Nollywood. What we grew up knowing is that
I can understand.
In movies, once the
they
papa
read
dies,
the will in the mass parlor, in the sitting room.
Exactly. And on the day I when I saw it and I eventually found out, that you
it's
think
not done there. Wills are
I
not
was
read in your
like,
sitting
oh
room.
my God, see what movies have, cause, and I know
Nigeria.
that there are lots of people listening to this podcast right now that
Who
actually
still
think
believe
that,
and think that
that's how it works. Please, can you educate people? Where do you keep your will and codicil?
First and foremost, it's good to understand that when your will is prepared and it's signed and executed and all of that, your will is lodged at the probate registry of the High Court of any state that you are in. Some people actually do their wills and lodge it in the bank, actually. But the number one place where wills are lodged is in the registry, at the probate registry of the High Court, because they are the ones that give effect to your will, because a will must be proved before it can be of any benefit to anybody.
What do you mean proved?
Proved in the sense that your will, you must get what we call a probate instrument from the probate registry of the High Court in the state where it was lodged, so that they can issue your executors what we call a probate letter or probate instrument after payment of the necessary fees and estate tax to the government. They will issue your executors the probate instrument that they're going to use to dispose of that property that you want them to give to Dele, the one you want them to give to Lano, want them to give to people that Kayode, to give to Lagbaja and all the others. You understand? And then for that to be done, when a person dies, unlike Hollywood, when a person dies, your will is not read in your living room.
You're living with your children around the table.
No. That is a Nollywood style. In real life, wills are not read in your lawyer's office. Your lawyer is not going to come to
So
you.
that one is, we said Nollywood, that is Hollywood.
Yes, in your lawyer's office.
We'll soon go to Bollywood. We don't know what those ones do.
In your lawyer's office, your wills are not read there. Your wills will be read at the probate registry, either at the deputy chief registrar's office of the probate registry or the chief registrar of the high court of the state in which the will was lodged. So normally what happens is that your family members will contact the lawyer, informing them of the demise of the testator or testatrix, and then the lawyer would apply for the reading of the will at the probate registry. So a date will be scheduled for that after payment of the necessary fees to the probate registry, and a date will be fixed for that, so that the children and all the family members that needs to be present for the reading of the will be present. The will number will be found. It will be brought out from the safe where it was lodged, to be unsealed in the presence of the family members, and then it will be read by the deputy chief registrar of probate or the chief registrar in the presence and in the hearing of the family members that have been invited. There is also provision for those that cannot come physically to join in by Zoom. So in the event there are children that may not be there for that, so they can join virtually. So your wills are not read in your living rooms. They are
So we
read
clarified that.
at the probate registry.
Your wills, I need, that's one of the things I wanted us to clarify that. Where are the wills read? Now,
They're read at
I
the
know
probate
that
registry.
I want us to deal with this issue as the owner of a will. How do you ensure that the will that you've prepared is found by your family members? The reason why I ask is that some people, you find that they said they written a will and they can't find it. Some people, they don't even know that the parent had a lawyer. They didn't know the parent wrote a will. You know, it is when you know that you have a family lawyer. That's when you will call the lawyer. So what would you, in your own experience, what can we put in place to ensure that for the benefit of,
For instance, you've made a will to
Yes.
ensure that that will is found
Yes.
and it is read
Exactly.
and your
So
wills
it's not
are
be- it won't be a
carried
waste-
out.
it's not a waste of
Yes,
time, yes.
Now, start by saying this. Even if you feel that there's nobody you trust amongst your family members or amongst friends, there must be one child that you trust. Even if you feel I don't trust any child, there must be one friend that you trust. There must be someone that you trust. So I'll start by saying I usually advise older clients that as you get older, at a certain stage, start involving a particular child into the things you do. Start intimating them of the confidentialities that you have. For instance, if you make a will, let one of your child know, the child that you trust know. If you have a lawyer, introduce your lawyer to your child, to the child that you have in confidence. And then now I'm saying this with a note of caution. Not that you introduce it to all your child. Well, if there's unity in amongst your children, why not? They can all know that you have a will. You don't have to show them. You don't have to show them the content, but introduce them to your lawyer and let them know that I have a will. It is important you let your children know if you have a will. Let them know, and then let them have the contact of your lawyer and his details, so that in case of anything, you can call Mr. This.
No. Okay, I was going to check that. Not that I have a lawyer, the lawyer is in the window.
No. Tell them the name of your lawyer. In fact, if you can, take them to his office. Let there be an easy transition from you to them, so that if anything happens, your lawyer is their first call. And the lawyer would know what to do. If your children are not that exposed, you can let them know that, okay, I've dropped some things with my lawyer, some things are in safekeeping with him. Let him know in the event of anything, I have a will lodged with him. You understand? You can even tell them, most times when your lawyer lodges your will for you, he gives you the lodgement number and the receipt number. The receipt and the lodgement number is what is used to apply for the reading of your will. So there's nothing wrong with you letting your child know your will lodgement number and the receipt number.
It's not like they can go and take it.
They can't take the will because a will cannot be unsealed until the testator or testatrix is dead. Because you must show the death certificate of a deceased person or of a testator or testatrix before a reading of the will can even be scheduled. So it's always good if you have a will, let your children know. If there's a lawyer on the other side, let your introduce them to the lawyer. If it's not children you have family members that you trust, let them know that there is a will. I have a lawyer. It is with this, be specific, so that when things happen, they are not thinking which lawyer did mommy drop this with. No, take them, if possible, take them to the lawyer. Let them know his address. Let them have his contact. And then it also helps to have you can have a jotter or a book where you write down basic informations for them. You can tell them in case of anything, of any emergency or last minute details. I drop some information in this. You can find any number, any contact, or any address you need in this book. So it helps to give closure for elderly people.
We were talking about people that of sound mind. So whether you're young, you're old. I want us to talk a bit of people that might be listening, and maybe they have somebody who is incapacitated, and they have properties, and they didn't put structure in place, and plan an estate. Can anything still be done for those people in terms of estate planning?
Yes, you can have a power of attorney. Maybe if you're incapacitated.
So what is the power of attorney for the benefit of our listeners?
Power of attorney is a legal instrument or a document in which you give or you transfer the power you have to make decisions, maybe financial decisions, property decisions, basic decisions that concerns your assets, to a trusted person to take those decisions for you on your behalf, and which if it is brought to you, you can ratify it. By ratification, you approve it, you endorse it, you have authorized it, so you have backed it up. You can see instances like that where maybe someone is ill and is not in a position to sign checks, checkbooks, and all of that. You see, that's where before the illness gets to the stage where you can't even sign anything at all. It's always best you can do a power of attorney, transferring your rights or your decision making abilities to maybe
somebody you trust,
your child or your daughter or your son that is always available, that is helping you out where there's trust. Of course, we know there are instances where such trust is being abused, but that doesn't remove from the fact that you can be able to transfer your rights or abilities in such situations to a trusted person that will still get it done rightly with good intentions.
So as you were talking, I realized you can even have a situation where someone who already has a will has instances where the person has to appoint
a power of attorney to someone.
Now, in an instance where such a person then eventually dies, and the person never had a will, in such an instance, how do you then administer the estate of the person who died without a will?
Well, without a will, power of attorney is usually enforced for the lifetime of the person. When a person dies, the power of attorney is no longer in effect. The power of attorney is no more in effect. So that's why when somebody dies without a will, the family can come together and decide on appointing what we call administrators or administratics for the administration of the estate of that deceased person. So it could be a minimum of 2. The law allows a minimum of 2 administrators and a maximum of 4 administrators for each estate. However, where there is a dispute in the estate, the administrator general and public trustee, that's what we call AG&PT, can come in to administer the estate of a deceased person where there's contests and the people are not able to agree as to the distribution of assets. So the instances like that still occur. So where there's no will, you would have to process the deceased family members would have to process letters of administration for the estate.
Thank you for joining us in this episode of the Central Law Clinic podcast. We hope you enjoyed the conversation. You can listen to more episodes like this on our YouTube channel or wherever you listen to your podcasts.